got Kevin Logan here to speak about some of the trial issues as well.
Mr. Logan?
Thank you.
Yep.
Have a seat. Mr. Chairman, Kevin Logan, I represent Virginia Farm Bureau Mutual Insurance Company. All of the reasons that Mr. Legault stated for insurance purposes, I certainly endorse, but there's a real practical concern here dealing with joint and several liability. I sit on the McComfrey on the Boyd Graves Conference. Comparative negligence has come up many times and has always failed because there's no workable way to have comparative negligence and joint and several liability. The example Mr. Legault cited, 2 tortfeasors involved in an accident. How are you going to parse out culpability? How are you going to deal with the issue of potentially contribution between the tortfeasors? What about third-party practice? It's more of my concern is more as a lawyer. Third-party practice is going to be upset. I've talked to several of my colleagues, both trial lawyers and defense lawyers, and almost unanimously they all agree that the real practical problems are the issue here with comparative negligence.
Okay.
And yes.
Well, this is not, is this a comparative negligence?
It's not.
It's not. I mean, let's say, someone's, riding a bike and let's say they're crossing an intersection and they get hit by a car. And maybe there's multiple cars involved, maybe they're, each one, they're jointly and severally liable.
If they're all negligent.
If they're all negligent. Then the question would be, is the bike rider causing his own injury? And is his negligence greater than the aggregated total of all the other defendants?
Right.
So I guess the jury's gonna have to do some type of calculation as to, well, this one's X percentage, this one's Y, or how's this gonna work, Scott? I mean, what does the jury instruction gonna look like?
I'm sure Mr. Deming has a standard instruction he uses in DC when he's had to deal with this, and they've used it there, and it didn't, all these problems that are being described didn't happen, but the jury just has to decide whether the cyclist was more at fault than the other people who were negligent. And if they decide that the cyclist was, they get 0. If they decide that the other defendants were negligent and that was more, then they all have to pay jointly and severally the same amount. They have to do contribution between them. If one of those joint and several parties had no negligence, they're out. This is not comparative negligence. It was specifically designed to avoid repealing comparative negligence, and that's why it passed in DC.
Okay.
If I may, Mr. Chairman, also, the cases involving multiple vehicles and a cyclist injured are incredibly rare. In 30 years of practice, I've never seen a single one.
Okay, well, that may be the answer. All right, a more, sort of a more material question is, I think, and I'm lukewarm on this. I like comparative negligence because it's easy to understand and we've had it, and there's a lot of case law built up on it. And I've had, contrib, I'm sorry. And I've had arguments before juries where they figured it out that, okay, this may have been negligent by the victim, but that's not really what caused the accident. They can work through that. I don't like, if we do pass this, and again, I'm lukewarm on it, I think it does moot last clear chance. I don't think you can still have last clear chance at that point. I don't see how you can have both. Albo.
Mr. Chairman, Dave Albo.
Give us the right answer.
I represent the Virginia Association of Mutual Insurance Companies, and this doesn't really affect them because it's automobile, they do mostly property and casualty, but they wanted to communicate to you, this is the camel's nose under the tent, first ornament of the Christmas tree, and here we go. And so they're very opposed to the concept as it applied to property and casualty.
Jim.
Jeff Palmer on behalf of the Virginia Chamber of Commerce. I think it's been long understood that the Virginia business community and the trial lawyer community had an equilibrium between contributory negligence and joint and several liability. And this bill would, in these admittedly limited cases, would take the best of both worlds and adopt comparative. Even though you're not calling it, you're assigning the liability of all the parties and comparing them to each other, So comparative negligence and joint and several liability. So it's really upsetting that, that equilibrium that's long been established in Virginia. We also have issues with treating different tortfeasors in the same set of facts differently, with some being treated under a contributory scheme and some being treated differently
All right,
under a impaired
one other
scheme.
question, Scott, it says on a public highway. Is that basically every public roadway, including cities and towns?
Under 46-2, it's any road that's open to the public and doesn't have restricted access, and that would include parking lots. If there's no like restriction on the parking lot, you know, you can only use
So
it.
even private parking
It
lots?
could be. If there's no sign on the parking lot restricting its use, it could be.
Okay, but if they're in like, within a private roadway, then obviously this would not apply.
If there's a sign restricting access to the road, then it would not apply. If it's a private road that has unrestricted access, it could apply. That's how the DUI implied consent regime works, is it
Okay.
keys off a public highway.
All righty,
I have some responses to all that.
okay,
Right.
Scott, you get the last word, it's your bill.
So, I don't know anything about this equilibrium, I'm not part of that, but what I will say is that the reason I think it's important to carve out pedestrians and cyclists is that because they are at a significant disadvantage in these scenarios because of the physics involved in these situations. And I'm sure anybody can go ask our caucus chairman, what she remembers from her collision, I'm pretty sure it's nothing. And frequently when you're a pedestrian or cyclist and you're struck by a car, which has happened to me 3 times, well, I remember all 3 times, you frequently either don't remember or you end up dead. And it's often very hard to make a case because the evidence doesn't exist. Also, the forensic evidence on the vehicle is very limited. When a body or a bike hits a car, there's not a whole lot of indication on the car of that. Just a little bit. You get a mangled bike, you get a person that doesn't remember anything, or is dead. The injuries tend to be severe and significant, and so if you have a standard where the jury can assess fault more fairly, and I think there's also a little bit of prejudice out there against cyclists and pedestrians amongst drivers, I think this better balances the tort playing field for these people who are vulnerable to a more severe injury and disadvantaged within our system. And that's why it was passed in the district. Pedestrian cyclist deaths and injuries are way up in this country over the last 5 years. They're increasing at an increasing rate as we get more and more of this transit-oriented development. It's gonna be an increasing problem, and we need to make sure we have a playing field that fairly treats people when they get hurt.
Okay, all right, we operate by motion, gang.
Move to report.
All right, Jennifer moves for report, I'm gonna second Jennifer McClellan, even though I have no idea what she said, just so we can put it out there. I gotta be honest, this is tough for me, cause I wanna be helpful to the bicyclist community, but I also do not like taking our laws of negligence and creating sort of subcategories within them. I feel like we have a good set of jury instructions, juries understand them, so at this point, I'm gonna vote no, but I don't know, we'll see how the committee goes. All right, we have a motion and a second to report the bill. All in favor, say aye.
Aye.
I'm gonna vote, well, I don't really know Lucas and McClellan. John, are you on this committee?
Yeah. I'm actually with you.
Oh, okay. All right, so we have 2 ayes.
I think Lucas would probably.
All right, just to keep this thing moving forward, I'm gonna vote Lucas and McClellan aye, so you have 4 ayes.
It was 4 either way, yeah.
That's
Three
true.
noes.
You got 3 noes?
Got 3 noes.
All right, I'm gonna give you another no, so you got 4 to 4.
Okay.
All right? I think this is gonna need a lot more discussion, because again, contributory negligence is a pretty key component of our tort law, and this will be the first time we have alternate.
Got it.
Okay?
Okay.
All right, that's what we're gonna do today,